I was curious because the charge in my own hand was not a filed copy. It was not. It didn't carry matter of the court. There was no sign that it was a copy that had been duly filed. So we raised it before the magistrate that this charge with us was like a piece of paper. We thought they were just coming to file this morning, and the magistrate confirmed that they had filed since on the 19th. And as since they are filed on the 19th, we have to move the bail application of these individuals. And we moved the bail application, and it was granted that each person should be released on bail in the sum of 500,000 naira and one surety in the like sum to be resident in Abuja and to have means of identification and means of livelihood. So that yesterday, we had about more than 15 people in court who were ready to stand surety. We selected the 5. In the course of gathering their documents, we couldn't perfect everything till 4 o'clock. Today, now they had done everything, they had done verification. It's just for the magistrate to sign. So by the time we left the court, it was also close, very close to 4 p.m. We know that if they sign today, if the magistrate signed today, there's some way we could process the process of bringing them out from the office of JSS. So hopefully by tomorrow morning, we are thinking of getting reunited with these citizens of Nigeria, prisoners of conscience. That's our hope.
Thank you so much, Barrister, for all the work. But quickly, I just want to get something clearly. Like the first court gave bail order, and the DSS failed. It was the second court that gave all these bail conditions, including 500,000 naira, shorties in like sum and all that. I just want that to be clear. So that means you now have 2 bail orders from 2 different courts. Is that correct, Barrister?
Also, that is correct. The clarification is that the order given by the Federal High Court was not a bail. It was not a bail. It was an order of release, unconditional release. They have been detained since the 4th of July. So by the affidavit evidence we placed before the court felt moved that, look, if these individuals had been detained since 4th of July, you didn't charge them to court before they brought this application. That was what prompted the court to hear our bail application, our ex parte application, because there are 2 applications before the Federal High Court. The substantive one is the one where we are asking for the court to declare the arrest illegal and unconstitutional based on the fact that it violates their right to freedom of thought, it violates their right to freedom of expression, it violates their right to freedom from discrimination based on the fact that only 5 people out of more than 1,000 in the church who were singled out for arrest. It also violates their right to personal liberty. So the court is going to pronounce on that. Aside the motion on notice, we now file a motion ex parte that pending the hearing of the motion on notice, which would take 7 days, it could take 3 weeks, it could take a month. The court should listen to this motion ex parte and grant interim relief. That is the provision of fundamental right enforcement procedure rules. That if you have an application before the court asking for relief in respect of the violation of your right, you can also still bring another application ex parte. Ex parte means you don't even have to serve the other party. Let the court listen to you first. If the court sees merit in what you are praying, the court will listen to you and do the needful. So the court had the motion ex parte. We made it in alternatives. The first thing is that we asked the court to give them bail pending the hearing of their motion on notice. Or in the alternative, the court should order their immediate release from custody. Or in the further alternative, the court should order the DSS to produce them before this court so that we can even see them. But in the infinite wisdom of the court decided to choose the one that the court thinks will satisfy the interest of justice. And the court ordered immediate release. Said release forthwith. And the dictionary meaning of forthwith is immediately. That they should be released. No condition attached. So if ordinarily the order of court that was given on the 26th of July had been served on the DSS, it is either they just release them to us. They cannot be talking about shorty. Because shorty will have to be that you are bailing somebody. Somebody will have to come and stand. But this one court is saying release them with immediate effect. So we could have released them before the court will hear their motion on notice for the enforcement of their right. But the order was given on the Monday. And that was the day Kanu's trial came up. It was a rowdy session in that court. Before we even We were able to in court. It was almost getting to around 4. We couldn't process any order. So the next day when we were supposed to process that order was that 27th. It was that 27th that they now invited us that we should come and release these individuals. For you to look at some of these things, which to me I have forum that it looks to us like a scheme, you know, because that 27th we could have processed the order. We could have taken it along. Ordinarily, they have perfected the plan to make sure that they bring these people before another court. For you to know that they claim to have filed of July. So what are they doing? It is not even come to the notice of the defendant themselves. So it's like somebody trying to get a backup that these people, if they want to be smart, will bring out like plan B or Joker B or something. So that is why they said they filed a charge since 19th. And it was after the order of the court came up. They now rushed them to file, and they kept that. So now the point is that my feeling is that whether we are able to serve the order on them or not.
Yes, let me just quickly ask one thing now. Okay. Sorry to break there.
Yes.
Who filed? Is it the DSS or the church, or DSS and in conjunction with the court? Who filed this motion?
Is it the motion or the charge?
The charge. I mean the charge. I'm sorry to
yes, it's the DSS. You know, the church could not obviously file any charge. It was filed by the DSS.
What is content of their charge?
Yes, the charge is a charge of 5 counts. The first count in that charge says that these 5 individuals conspired to cause a breach of peace at Dunamis5. The second count says that these individuals indeed caused breach of peace at Dunamis5. The third one says that these individuals, they conspired to provoke disturbance to public peace at Dunamis5. The first one says that these individuals, they intentionally insult to provoke disturbance to public peace. And the fifth count now says that they consider themselves into vagabonds. You know, it's very, very laughable. At Dunamis5. I don't know that a vagabond could be within that church. You know, people who came to worship say they are vagabonds. They were not seen under the bridge.
But Barrister, is it possible for the DSS to take this kind of charges up on behalf of the church without the church being part of this, or without the church filing complaints officially to the DSS?
No. The point is that if we proceed with that matter, we know who is the complainant. We know if it is the church that is the complainant, they will come to court. Because ordinarily, apart from the fact that the problem with the issue of whether the DSS people even have the powers to arrest and prosecute people, that one is still hanging, that one is there. But let us even assume they have the powers to prosecute now. When individuals make a report, it is the states, whether the police or whoever, whether the civil defense or SSS, that will still take the charge before the court, not that complainant. It's not going to be that complainant. But at the end of the day, there's no way you'll be able to do trial without the complainant. You know, the present state of our law now is very retrogressive. The Administration of Criminal Justice Act 2015, in section 221, made provision for the fact that you cannot raise objection to the validity of a charge, whether during proceeding or trial. And if we eventually raise it under section 396, subsection 2, the court cannot pronounce on it until the end of the trial. So if we try to be in those days when we operate strictly under law, criminal procedure code in Abuja now, we will have raised objection to that charge for the court to strike it out yesterday on 2 grounds. The first ground is that the charge does not have any particular. If you say somebody disturb public peace, you must be able to state categorically what the person did to have constituted disturbance of peace. Is it that he got to Dunamis5, he was abusing people? Is it that he got there, he blocked the road? Is it that he got there, he was trying to rough handle people without mentioning the specific acts that constitute all of these conspiracy, intentionally insult? If you say that they intentionally insult and they want to provoke public peace through that, whom did they insult? So the charge was drafted in a very dodgy manner. Like they were not sure of their complainant. They were not sure whether the complainant was bold enough to come out. So they did not want to link, because the only thing they can do to make the charge valid is to disclose the particulars. Okay, you people, you came to this place, you insulted the pastor in charge, Pastor Enenche. You thereby provoke disturbance of public peace. Or you people, you got to this place, you were disturbing worshippers. You were shouting songs, thereby you caused breach of peace. This is the format of a charge. This is the way you have been. But they deliberately or purposefully didn't disclose those things because they knew in the course of doing that they were going to reveal their complainant. So my fear, even as of today, is that the church might not be able to come out boldly to say they are the complainant, despite the fact that we know they are, because they were arrested at Dunamis. That is what the church carry. All the guns, Dunamis church, at Dunamis church. So if somebody is arrested at Dunamis church, it must be at the instance of the church. And for you to now look at where, which is a very dangerous one. So if somebody is in a private house now to make noise, you have police stations around. The next people you are going to call are the DSS, because they are the only one that are the bad guys that can carry out any of such oppressive or conscienceless persecution of citizens. That is what they are. So for me, there's no way the church can wash its hands clean from this. All the charges, all the counts.
Yes, Barrister.
At Dunamis church.
Okay, let me just ask now: is there any hope that you'll be able to perfect their bill and will be able to find? I mean, meet with these people by tomorrow. Is there any assurance?
They should come. They should come out tomorrow. They should come out tomorrow. We are very hopeful. We are very hopeful. We are very hopeful tomorrow.
Yeah, thank you so much, Barrister. I mean, we don't want to also preempt the court or make too much assumptions at this point. But we just wanted to hear the updates, and we think you have enough of it already. I'll let you go now so that you can continue to do the rest of the work. By tomorrow, hopefully, we'll come back to hear the updates. Hopefully, they would have been arrested.
Yeah, we appreciate. Thanks.
All right, thank you very much, everybody. That is the little we can take. It's just to get updates from the barrister. That was Barrister Tope Temokun, and it's the one who is taking on the case with the Dunamis5, who were arrested at the premises of the church in Abuja. And then the DSS, in summary, is filing on behalf of the church, and then the church has refused to allow the DSS release them. So 2 courts have ordered their release already. One federal high court ordered their unconditional release. Immediately they were supposed to be released, or their release perfected. The DSS took them quickly to another magistrate, where they were still granted bail in the sum of 500,000 naira each in like sum. And the bills are being perfected according to the barrister. Hopefully, they already perfected them, so we expect that if you can't get them today, at least first thing tomorrow. Hopefully. Don't forget we are dealing with the DSS, and any funny thing is likely to come, but we are hopeful. I mean, in the end, they must surely release them, so we hope that tomorrow will be the peak of it. Thank you very much for your time watching this quick interview with Barrister, and I will bring you updates tomorrow. Bye for now.